नमस्कार दोस्तों, लीगल गुरुकुल में आप सभी का बहुत बहुत स्वागत है। दोस्तों, आज के इस वीडियो में हम इंडियन एविडेंस एक्ट के क्वेश्चन नंबर 21 to 50 यानी कि 30 क्वेश्चन जो हैं हम इस वीडियो में डिस्कस करेंगे। इससे पहले के वीडियो में हम जो है 20 क्वेश्चन इंडियन एविडेंस एक्ट के क्वेश्चन नंबर 1 to 20 डिस्कस कर चुके हैं। दोस्तों, ये क्वेश्चन जो है ये सभी क्वेश्चन आपके जुडिशियल एग्ज़ाम्स के लिए, चाहे वो लॉ एंट्रेंस का एग्ज़ाम हो, क्लैट का हो, यूजीसी का एग्ज़ाम हो या अदर लॉ कॉम्पिटिशन हो, उन सब में ये आपकी सहायता करेंगे। तो मेरी आपसे यही रिक्वेस्ट है कि आप इस वीडियो को पूरा देखें, और यदि आपने लीगल गुरुकुल चैनल को सब्सक्राइब नहीं किया है तो प्लीज़ 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 जाके सब्सक्राइब कीजिए, ताकि जो भी वीडियोज़ लेटेस्ट वीडियोज़ आपको मैं बना रहा हूँ आप तक जो है जल्दी से जल्दी पहुँचें। तो ज़्यादा देर ना करते हुए चलिए शुरू करते हैं आज के इंडियन एविडेंस एक्ट के 30 क्वेश्चंस। क्वेश्चन नंबर 21, ए डिस्प्यूटेड हैंडराइटिंग कैन बी प्रूव्ड। ऑप्शंस हैं ए बाय कॉलिंग एन एक्सपर्ट, बी by examining a person acquainted with the handwriting of the writer of the question document, C by comparison of the two admitted and disputed handwriting, D all of the above. And the correct answer is D all of the above. Question number 22, under which section opinion as to existence of right or custom is relevant? Option A, under section 46 of the Evidence Act, B under section 47 of the Evidence Act, C under section 48 of the Evidence Act, D under section 49 of the Evidence Act. And the correct answer is C under section 48 of the Evidence Act. Question number 23, in relation to proof of age, options are option A, opinion of radiologist is relevant, B, entry in the registrar of births and deaths is relevant, C, opinion of radiologist cannot be preferred over the entry in the register of births and deaths, D all are correct. And the correct answer is D all are correct. Question number 24, the opinion about digital signature is relevant under option A, section 47A of the Indian Evidence Act, B, section 27A of the Indian Evidence Act, C, section 21A of the Indian Evidence Act, D, none of the above. And the correct answer is A, section 47A of the Indian Evidence Act. Question number 25 पे चलते हैं. In which of the following famous case the expression person in authority has been defined? Option A, Kisan Singh versus R, B, Palvinder Kaur versus State of Punjab, C, Santoshi Beldar versus R, D, Syan Kaur versus State of Punjab. And the correct answer is C, Santoshi Beldar versus R. Question number 26, grounds of opinion are relevant under A, section 50 of the Indian Evidence Act, B, section 51 of the Indian Evidence Act, C, section 52 of the Indian Evidence Act, D, section 53 of the Indian Evidence Act. And the correct answer is B, section 51 of the Indian Evidence Act. Question number 27, the relationship in section 50 of the Evidence Act means A, relation by blood only, B, relationship by blood or marriage, C, relationship by blood or marriage or adoption, D, neither A nor B nor C. And the correct answer is C, relationship by blood or marriage or adoption. Question number 28, character of a person become relevant, A, when it is fact in issue, B, when it becomes evident from other relevant facts, C, when it affects the amount of damages, D, all of the above. And the correct answer is D, all of the above. Question number 29, in criminal cases previous good character is relevant under A, section 52 of the Indian Evidence Act, B, section 53 of the Indian Evidence Act, C, section 54 of the Indian Evidence Act, D, section 55 of the Indian Evidence Act. And the correct answer is section 53 of the Indian Evidence Act, that is option B. Question number 30, The Indian Evidence Act declares that anything said, done or written by any one of the conspirator is relevant to prove conspiracy if it was in A. Pursuance of their common intention, B. Reference of their common intention, C. Prosecution of their common intention, and D. Redeeming their common intention. And the correct answer is B. Reference of their common intention. Question number 31. Which one of the following is not a correct statement about expert opinion? A. The opinion of an expert is seldom conclusive. B. Fact which is irrelevant becomes relevant when they support the opinion of experts. C. Expert opinion is binding on the judge always. And D. The evidence of expert is a suggestive piece of evidence. And the correct answer is C. Expert opinion is binding on the judge always. Question number 32. Section 58 of the Indian Evidence Act deals with A. Formal admissions, B. Evidentiary admissions, C. Formal as well as evidentiary admissions, D. Proof of fact by oral evidence. And the correct answer is A. Formal admission. Question 33. Which one of the following statement is correct? Hearsay evidence becomes relevant A. When it is ratified by admission or confession, B. When it comes under the ambit of section 6 of the Indian Evidence Act, C. When it is mentioned in any public document or is presumed by the court, D. All of the above. And the correct answer is D. All of the above. Question number 34. Under which of the following section of the Indian Evidence Act opinion as to digital signature is relevant? Option A. Section 34, B. Section 3, C. Section 47A, D. Section 85A. And the correct answer is C. Section 47A. Question number 35. The contents of document may be proved by A. Primary evidence only, B. Secondary evidence only, C. Primary or secondary evidence, D. None of the above. And the correct answer is C. Primary or secondary evidence. Question number 36. Secondary evidence is A. Certified copies of the original document, B. Negatives of a photograph, C. Oral account of contents of document, D. All of the above. And the correct answer is D. All of the above. Question number 37. Which of the following documents are not admissible in evidence? Option A. Documents improperly procured, B. Documents procured by illegal means, both A and B, D. Neither A nor B. And the correct answer is neither A nor B. Question number 38. Oral evidence under section 60 of the Evidence Act may be A. Direct only, B. Hearsay, C. Both A and B, D. Either A or B. And the correct answer is A. Direct only. Question number 39. Contents of a document may be proved under section 61 of the Evidence Act A. By primary evidence, B. By secondary evidence, C. Either by primary or by secondary evidence, and D. Only by primary evidence and not by secondary evidence. And the correct answer is C. Either by primary or by secondary evidence. Question number 40. Secondary evidence is admissible A. Where the non-production of primary evidence has not been accounted for, B. Where the non-production of primary evidence has been accounted for, C. Irrespective of whether the non-production of primary evidence has been accounted for or not, D. Both A and C are correct. And the correct answer is B. Where the non-production of primary evidence has been accounted for. Question number 41. Secondary evidence of a document is admissible as a substitute for A. Admissible primary evidence, B. Inadmissible primary evidence under certain circumstances, C. Inadmissible primary evidence under all the circumstances, D. Both A and B are correct. And the correct answer is A. Admissible primary evidence. Question number 42. A document required by law to be attested can be proved under section 68 of the Evidence Act only: A. By calling both the attesting witnesses. B. By calling at least one of the attesting witnesses. C. By calling one of the attesting witnesses but by calling some other person who has the knowledge of the contents. D. All of the above. And the correct answer is B. By calling at least one of the attesting witnesses. Question number 43. Secondary evidence of a document means: A. Copies of that document. B. Oral account of the contents of the document. C. Both A and B. D. Only A and not B. And the correct answer is C. Both A and B. Question number 44. Oral account of the contents of a document is admissible: A. When given by a person who has seen and read the document. B. When given by a person who has seen but not read the document. C. When given by the person to whom the document was read over. D. When given by any of the above. And the correct answer is A. When given by a person who has seen and read the document. Question number 45. The circumstances under which the secondary evidence is admissible have been enumerated in: A. Section 63 of the Evidence Act. B. Section 64 of the Evidence Act. C. Section 65 of the Evidence Act. D. Section 66 of the Evidence Act. And the correct answer is Section 65 of the Evidence Act. Option number C. Question number 46. The calling of at least one attesting witness to prove a document under Section 68 is not necessary. A. When the document other than a will is registered under Indian Registration Act 1908. B. When the document including will is registered under the Indian Registration Act 1908. C. When the document, irrespective of whether it is a will, is registered under the Indian Registration Act 1908. D. Both B and C are correct. And the correct answer is A. When the document other than will is registered under the Indian Registration Act 1908. Question number 47. Maxim omnia pro assumuntur right estacata means: A. All acts are presumed to be rightly done. B. All acts are presumed to be not rightly done. C. All acts are presumed to be wrongly done. D. All acts are all acts are presumed to be not wrongly done. And the correct answer is A. All acts are presumed to be rightly done. Question number 48. Public documents are mentioned in: A. Section 72 of the Evidence Act. B. Section 73 of the Evidence Act. C. Section 74 of the Evidence Act. D. Section 75 of the Evidence Act. And the correct answer is C. Section 74 of the Evidence Act. Question number 49. A will is required to be proved by calling at least one attesting witness: A. When it is registered. B. When it is unregistered. C. When it is admitted. D. All of the above. And the correct answer is D. All of the above. Question number 50. Oral evidence under Section 60 of the Indian Evidence Act may be: A. Direct only. B. Hearsay. C. Both A and B. D. Either A or B. And the correct answer is A. Direct only. So friends, these were the next lot of 30 questions of Indian Evidence Act, that is question number 21 to 50. These questions will help you in all the judicial exams, whether be it is law entrance exams, CLAT exams, UGC exams, any other law competition exam. So please go through these questions. I request you, these are very helpful, and next time I'll come up with another topic, another subject. So till then, goodbye, Jai Hind.